inserting 1A that reads, the provision of subsection 1 shall not apply where at the time of death it is the intestate who separated from the surviving spouse. And B, so for instance, in a marriage, the husband decides to leave you. Remember, we introduced in our definition the element of consent. The separation must be as a result of consent or a judicial order. And those judicial orders are known. There's the divorce order and the judicial separation order from court. So where you don't fall within any of those, it's definitely not with consent, unless you deserted the home. Then you don't stand to benefit. But where the husband decided to walk out, or the wife, let me be neutral. Where the husband or wife decides to walk out without consent, you're still willing to be in this relationship. You're still willing to be married. The other party decides to walk out. Then you're not separated. And you're entitled, because for you still wanted to be in this marriage, you still wanted to make it work. So you're entitled to benefit from that. That's why we are saying here, we are introducing that where at the time of death, it's the intestate who separated from the surviving spouse. The surviving spouse did not want. Then that subsection 1 does not apply. Because this is a very common occurrence, by the way. Women are either driven away from their homes, women or men are either driven away from their homes, or due to circumstances within that which they could be, they are beaten every day, that they cannot stay, and yet they might have wanted to stay. Or one day, a spouse decides they've had enough and they walk out, and yet you're willing to stay in the marriage. This section should not apply, where they say you should not take any interest in the estate because of separation. That is why we thought it very important to introduce an element of consent. And where both of you consent, it's okay. Or where it is you who lives, you're not entitled to to the proportion of an estate because you upped and left. So that's what section 1A provides for. By substituting for subsection 3, subsection 3 is application to court by such husband or wife or on their behalf. A court may, on application by or on behalf of the spouse after distribution of the intestate property, declare that subsection 1 shall not apply to the applicant. So this one protects those who are separated as a result of consent. We'll move on to our clause 16, repeal of section 31 of the Principal Act. This one was repealed because it was also declared unconstitutional. It was declared unconstitutional by the court in Law Uganda versus the Attorney General. Similarly, we have done the same and repealed. Let's go back to section 31. I think we skipped that. Section 31, repeal of section 31 of the Principal Act. Section 31 reads as it is currently, notice to be given by a customary heir. Upon the appointment of a customary heir of an intestate, the heir shall give or cause to be given notice of the appointment in a form set out in the third schedule to this act, to the personal representative and to the Administrator General. So this section was repealed. First of all, it was repealed by the Constitutional Court in that case of Law Uganda versus the Administrator General. Then secondly, also a customary heir now is a ceremonial function. Apart from being ceremonious, they do not play another role because you have an administrator of your estate, you have a legal heir, you have a spouse in the event that you're married. So there is no need for the customary heir to give notice, yet theirs is a customary function. That is too much trouble for nothing. And as I mentioned, also it was declared unconstitutional by the Constitutional Court. We move on to our clause 17, which repeals section 34 of the Principal Act. Effect of marriage between persons, only one of whom is domiciled in Uganda. So even this section was declared as unconstitutional as well by court, and it read, if a person whose domicile is not in Uganda marries in Uganda a person whose domicile is in Uganda, neither party acquires by the marriage any rights in respect of any property of the other party not comprised in a settlement made previous to the marriage, which he or she would not acquire by marriage if both were domiciled in Uganda at the time of the marriage. So similar to the other section, I think it was section 13, this was declared unconstitutional because by marriage, even if I don't know if we all know this, but marriage revokes a will. If you had a will before marriage, upon marriage, that will is revoked because the interest of the other party in your property changes. So you can't say just because one of you is domiciled outside of Uganda, you do not have an interest in the property. So that has changed as well. So that was declared unconstitutional, and we've dealt away with it here in our clause 17. Moving on to clause 18, substitution of section 35 of the Principal Act. Section 35 reads, section 35 of the Act now, settlement of a minor's property in contemplation of marriage. The property of a minor may be settled in contemplation of marriage, provided the settlement is made by the minor with the approbation of the minor's father, or if he is dead or absent from Uganda, with the approbation of the High Court. Where does this leave the mother? Makes no mention of the mother. If there is no father, let's go to the High Court. Really, that is not fair. So here we are amending it to read, settlement of a minor's property in contemplation of marriage. The property of a minor may be settled in contemplation of marriage, provided the settlement is made by the minor. Not that a minor can get married while a minor, but in contemplation, that maybe as soon as I reach 18, I hope to marry the love of my life. So in contemplation of marriage, the property of a minor may be settled, provided the settlement is made by a minor with the joint approbation of the minor's parents. So we've amended the use of the word minor's father to include a mother, because both parents have equal parental rights over a child. So with approbation of the minor's parent or parent, if you only have one, if only one is living, or a guardian, because a guardian legally acquires what? Parental rights over a child under the Children's Act. But if none is living, you have no guardian, you have no parent, with the approbation of the court. And in this case, the court means High Court for purposes of this law. We move on to our clause 19, amendment of section 36 of the Principal Act. Section 36 provides for persons capable of making wills. So we just substituted here in our amendment, we substituted in subsection 2, where it reads, a married woman may by will dispose of any property which he or she could alienate by her act during her life. It reads, a spouse. So it has been replaced with the use, it was discriminatory against men. Then by substituting for subsection 3. Subsection 3 reads, a person who is deaf or dumb or blind is not thereby incapacitated for making a will if he or she is capable to know what she or he is doing by it. So deaf and dumb people they think that is derogatory language. So we've changed it to be more politically correct language. What is acceptable now? So a person who has a hearing impairment, a speech impairment, it even sounds better, or a visual impairment is not incapacitated for making a will if he or she is able to know what he or she does by it. So we have a better use of language there. Then C, we've substituted for section 4 the following. Previously they were making reference to a person who's ordinarily insane may make a will during an interval in which he or she is of sound mind. Again, the language is too much. So we've substituted that with use of the word mental illness. A person who ordinarily has a mental illness may make a will during an interval in which he or she does not have the mental illness.